Welcome to the IAPP web conference, Preparing for the CCPA Without Boiling the Data Ocean, brought to you today by WireWheel. My name is Dave Cohen. I'm the IAPP's Knowledge Manager, and I'll be your host for today's webinar. We'll be getting started with the presentation in just a minute, but before we do, a few program details. Participating in today's program will automatically provide IAPP certified privacy professionals who are the named registrants with 1 CPE credit. Others who are listening in can apply for those credits through an easy-to-use online form on our website. We'd also like to remind you that today's program is being recorded and will be provided free to registered attendees approximately 48 hours following the live event. We encourage you to ask questions at any time during the program by typing them into the Q&A field to the right of your PowerPoint window, and your questions will be answered by the presenters during the presentation after the presentation. Now on to our program, and I'd like to introduce today's panelists. Justin Antone is CEO of WireWheel and the former Acting Undersecretary of Economic Affairs at the U.S. Department of Commerce. And I'd like to mention that on the registration for the webinar, Justin was listed as just being part of the government, but he's actually been CEO of WireWheel for a number of years now. So Justin, welcome to the program. And can you tell us a little bit about your role over there at WireWheel and your background?
Sure. Dave, thanks so much for having me today. WireWheel is a full platform for both helping companies with management of privacy exercises like assessments and data discovery and subject rights, and we'll talk about that later. I started WireWheel with a phenomenal technical team about 3 years ago. And before that, I served in during President Obama's second term. Ultimately, I ran the part of the government that includes the U.S. Census Bureau and the Bureau of Economic Analysis. Dave, I might add, we were barely ever in the news during President Obama's second term, and they've gotten a lot more publicity since then. I also went into the government right after the Snowden disclosures, and in my role at the U.S. Commerce Department, led a lot of the discussions and negotiations with Europe on privacy issues like the EU-US Privacy Shield and similar issues around the world. So I have been working in the privacy space for, well, much longer than I would like to admit, and we're really excited about what we've been doing with companies at WireWheel and helping them tackle these tough issues.
Excellent. Thanks so much, Justin. And as I mentioned at the beginning, this is going to be an interactive session, and please encourage you all to submit your questions throughout the program. We're going to address them both as they come in, and we've also got a designated Q&A period at the end. But for now, let's get into the presentation itself. And so for that, Justin, I'll turn it over to you.
Dave, thanks. And as I said, at this point, a lot of the experiences and issues that I'm going to talk about today around helping companies tackle the new California Consumer Privacy Act without getting overwhelmed are based both on a really deep understanding of what companies need to do from the law, from the proposed regulations, which as we all know are in the process of being finalized, but also from practical on-the-ground experience that we've had with a lot of large, medium, and small companies at WireWheel, helping them implement a full subject rights request platform and an automation, and also helping companies be able to show exactly that information that you need to show to consumers around the right to knowledge under CCPA, and then managing the back-end compliance systems that you need to do in your role as a privacy officer, whether it's assessment automation, data discovery, or end-to-end subject rights request. That background has really helped prepare and give us a lot of knowledge that we wanted to share with the community around how to actually tackle the CCPA. So talking about the act itself, obviously the IAPP community is filled with PhDs when it comes to privacy. So I'm not going to spend a ton of time just focusing on the general requirements of CCPA, because I suspect almost every participant today is quite deep on a lot of the basic requirements. But I'll give you a sense of what we're seeing based on the Act itself, and then we'll talk through some of the implementing regulations and even what's coming in CCPA 2.0, which is hard to think about right now as we're all standing up our programs. Number one, there were two significant numbers that I saw in the last couple of weeks, because when the Attorney General started issuing its regulations, they also put financial implications for companies on the table. And if you've seen it, some of the economists have been estimating that it's going to cost companies between around, up to $50 billion to get 75% of the companies covered by the Act ready to tackle it. And it's really because of the focus in the Consumer Privacy Act around enabling human beings, our customers, consumers, people at the end of the day, to have better control of their data. And when the focus is on fulfilling requests around access, deletion, and opt-out of the sale of the data, it puts burdens on companies and people in your companies to really be prepared for that. So if you break that down, we've seen estimates that it's going to cost, somewhere around $1,400, as you're standing up your system to fulfill some of these requests as you get started, between the time of being able to take the request, collect the data, actually review it. These numbers will go down, especially if you've added automation to the mix, and you can get it to go down materially. But if you're relying on just a pure human cost, it can be quite high. We're also seeing, as a practical matter, a lot more focus on volume of requests because the estimates of volume of requests that we're seeing have been much higher than the kind of estimates we saw under GDPR. I think there's a couple of reasons for that, and we'll talk through that as we go, but we are seeing companies both in the B2B space, if they are selling data or are part of the MarTech world, or in the B2C side for certain industries, expecting to get much higher volumes of these kinds of requests. And one thing I should note is a lot of the estimates that, Dave, companies are putting together around subject rights, companies are putting into a single bucket access requests, deletion requests, and opt-out requests. I think most every company estimates that the number of opt-out requests you might get are much higher than, say, an access request or deletion request, but all of them require you to have some basic infrastructure to be able to see and capture those. The third major thing that we've seen really on, as companies have been preparing, is a growing awareness that when you're setting up your systems to really be able to tackle this big challenge around subject rights and ultimately being able to deliver information back to consumers, there's a huge focus on making sure that that entire system is safe, secure, and encrypted. And the reason I think for that is the incentives and the liabilities that are actually set forth in the Act itself. So if, for example, in the course of fulfilling a data subject request or a subject request under California, I think in California they use the term VCR, Verified Consumer Request. Just to keep it interesting, we'll try and sprinkle as many acronyms, Dave, as I can through the session today.
Sounds good.
But yeah. But so like, say when you're fulfilling a subject rights request or a verified consumer request, if your entire system all the way through was not encrypted at rest and encrypted at transit, then in the course of fulfilling that request, you could actually expose your company to breach liability. So because the CCPA has a safe harbor, and the safe harbor says as long as you're encrypted at rest and in transit, you're really keeping your system within privacy liability. Many of the companies we've been talking to have really been looking at making sure whatever system they put in place for fulfilling subject rights is secure and encrypted all the way through, because the last thing you want to do is start emailing around consumer files and consumer information in a non-encrypted way. So those are some of the bigger things we're seeing. And I'll add to this list one big requirement around CCPA, which is the opt-out of the sale of data, Dave. And the opt-out of the sale of data has some special considerations for most companies. And that's really a place where you're going to want to look at automation and making sure you have the right technical infrastructure in place to handle those technical steps. I'll cover them now. We can talk about them in a few moments if that'd be helpful.
Yeah, I was just going to jump in there, Justin, and say that I know that as people have been talking about getting ready for the CCPA, preparing for compliance, the do not sell requirement is one that's a lot of people are talking about. And I think that's because there's just a lot of confusion or a lot of questions out there about what do people need to do minimally to be in compliance for that, and kind of when do they need to have that ready. I don't know if you want to touch on that now, Justin, or cover that later.
No, that's a great question, Dave. What do you need, and when do you need it? So first of all, the biggest suggestions I really give these days, and I'll come next to the subject, the opt-out piece, Dave, is do something. Again, I strongly suspect that for the IAPP community, that all of our participants today have done something. They've at least got the basic way that you can think about taking a request. You have at least alerted your internal team members, hey, this may be coming. I advise almost every privacy team we're working with, go to your marketing team and buy them a coffee, buy them lunch, give them a hug.
Do it now.
That particular part of, yeah, do it now, because marketing teams are going to be your friends, and it's because both you need to show some things on your front-end site. You also are going to be asking them to help you collect and store and produce information back. So if you haven't at least done that basic conversation with your marketing organization, I would bring them into the conversation very quickly. And so that's number one. Number two, when you think about opt-out of the sale of data, I use, Dave, you and I were talking about this, but one of my favorite episodes of Seinfeld, when I was watching it years ago, involved Jerry going to a car rental agency. I don't know if you remember this. And Dave, I don't even know if you've ever seen Seinfeld.
Oh, absolutely. Big Seinfeld fan.
Yeah, okay, good. Yeah. Great. So he goes to a car rental agency, and he's made a reservation, and the car rental counter, at the car rental counter, he finds out they took the reservation, but as he finds out, they didn't hold the reservation. And the critical thing around the opt-out of sale of data is you need to really take that request for the opt-out of the sale of data. You need to hold it, and you need to make that information available to your company and even sometimes to third parties. So when I say here's the basic things you need to think about for opt-out of the sale of data, these are the technical elements we have been implementing for companies to get them ready for this. First, in the browser, you need to be able to take that opt-out of the sale request. You need to be able to put it on all of your websites publicly so that a person can see it. And that's one of the things you need to make simple and easy for your customer base. And so that's one simple step. You need to be able to record in, some kind of suppression list, and think, some organizations have more technical requirements around the suppression list, but you need to be able to record it by a cookie and some basic information or IP address that this was an opt-out request. You need to have it somewhere that your team can look at it, and if you're using data, especially more aggressively in your marketing campaigns based on that cookie information, you're going to want that suppression list to be accessible via APIs for your internal team. That again is technical infrastructure that you may or may not need, but you got to take the request, you have to record the request, and you have to make it available for your team internally at your company. Third, in the browser, there may be cookie activity, including the dropping of third-party cookies or cookie pools that as a technical matter violates or is inconsistent with CCPA's do not sell requirements. And so you want to look at what cookie activity is occurring on your website. Again, we help with that. And you want to make sure that you've at least thought about, hey, if somebody says I'm opting out of the sale of data, do I need to stop or pause certain third-party cookie activity on your website? So that's a critical thing to look at.
Hey, Justin?
And then, sorry, yes.
I just want to jump in quickly and ask you a question about that, because this is something else I've heard. If someone opts out of cookies, clearly they're stating that they don't want that. Do you have any advice on how that might constitute other decisions made by that particular consumer? Can you infer other decisions beyond just that opt-out of cookies, or do you just take it for just the cookie opt-out? Maybe that's a settled question. Maybe that's an unsettled question at this point.
No, that's a terrific question, and here's where we get to the hard part. A lot of these specific implementation issues are a little bit of a matter of judgment at the moment because, and I know the entire community is having a tough time with this, because the regs that give you some guidance on these issues aren't final yet. So they aren't going to be finalized until March, and the Attorney General is not going to start really enforcing this until July. So we're in this mode where the best advice I can give around this is make the best judgments you can, and when somebody says they're opting out of a cookie, it may or may not mean they're opting out of all sale of the data. So as a general matter, we're seeing folks say, okay, we're going to enable an opt-out of cookies, but we're still going to present an opt-out of the sale of data because they're not necessarily exactly the same. And then you want to create a suppression list that's tied to that opt-out of the sale of data. One thing we have been recommending is even if you're not sure whether you technically are selling data under CCPA, because again, that's one of those provisions that one could interpret, I do recommend setting up some way to capture a do not sell request just so you have a way to implement backwards depending on whatever the final regulations are. So to answer your question, Dave, we're generally seeing folks, although people have implemented in different ways, I'd say the majority approach we're seeing is folks saying, okay, a cookie opt-out might direct you to an opt-out of sale of data or might be independent from that. And either way, the main point is at least eyeball on your website what cookie activity is occurring and make sure you've thought about whether it's consistent with some of the language on the opt-out of sale of data.
That makes good sense.
And the last thing I'd recommend for companies on the opt-out request is think about how you will make your suppression list available to third parties if you're marketing on third-party platforms. Opt-out has some really interesting consequences because the law basically says even if somebody opts out of the sale of data, you as a company who's a first party working with that consumer are still allowed to surface first party ads to that person, and you may surface those third party ads on, say, the normal third party sites. And so that suppression list will become an important piece of infrastructure for you to be able to enable compliance with third parties on how they take, any data to surface first-party ads on third-party platforms. So Dave, I hope I answered your question. I know that was a little bit longer, but I'm also going to just highlight at the top here that while I've covered opt-out of the sale of data, a lot of the worries in the community are also around how do you really deal with an access request? How do you do this at scale? And one of the reasons that we've had a lot more interest in this access set of requirements is that CCPA focuses and enables these kinds of requests to come into a lot more B2B companies that might not have been focused on this, say, under GDPR. Because if you're selling or processing data in certain ways under CCPA, you actually have to be able to take a direct consumer request, even if you're traditionally a B2B company. And so here are the 5 critical things that you'll want as a part of infrastructure when you're dealing with access, deletion requests, among other things. And again, not every company has to tackle this to deal with scale, but you want to have thought through each of these steps and make sure you have a way to do it. The first is, of course, that you're going to want a way to take the request and verify that you know who the requester is. Because obviously one of the real risks is you somehow produce, Justin's data to Dave, and then you have effectively a breach under CCPA. So trying to take reasonable steps and make sure you have some way to do it, hopefully automated and safe and secure, will be a critical step for companies. You're going to want to be able to ticket and assign the requests in some way that you track it. Again, if you're receiving a handful of these requests, maybe you can manually do that. But once you start getting into 10, 20, 30 of these things, it starts, even a month, it starts to become a little chaotic, and you're going to want some way to do that. You're going to want some way to also collect and manage the data. And as I talked about, most of the companies we're working with are quite focused on making sure that you don't create any liability or security issue in the course of doing that. So you'll want to make sure wherever you're moving that data to review it and be able to fulfill is a nice, safe, and secure platform or space. 4,
Justin.
I'm sorry, go ahead. Yeah, go ahead, Dave.
I was just going to jump in here because I had another question that I know that many people are wondering about, and this, you're probably going to touch on this in encrypt and securely deliver information, but you mentioned earlier that, the encryption and the security of that information cannot be underestimated, and this goes right along hand in hand with being able to verify and authenticate those users so that you're not passing out information to somebody who's not the legitimate requester of that information. So just wanted to flag for you that if you cared to go a little bit deeper into those things, that would be interesting for the audience to hear, I think.
Yeah, that's, again, a great question. So verification and authentication of the requests is probably one of the toughest issues we're seeing, especially as companies try to make a determination of how sensitive that information is. Both the statute and the regulations, the proposed regulations, set a general set of guidance that's tough, but it basically says you should use that amount of verification and authentication as you need to feel comfortable that you're producing, sensitive data to the right people. So in some ways, the more sensitive, identifiable that information is, the more you're going to want to do to make sure that the data is getting to the right person. The second thing is, remember that although the law goes into effect on January 1st, you have 45 days to produce that first data, even if the requests come in on January 1st. And you can, of course, take an additional 45 days if you have some reason to do it. And of course, and if, for example, you weren't confident you were producing it to the right person, that seems like it would be a very reasonable basis to delay a little bit to get additional comfort.
Well,
so the
Justin,
kinds of, go ahead.
If I could just jump in here quickly on that note, because this is quite important, and maybe you're going to cover this, is the look-back period. Did you want to make mention of that?
Yeah, there is a 1 year, you're right, Dave, there is a 1 year look-back period, and the Attorney General has talked about the fact that his office will, although they're beginning enforcement in July, they will be looking at how companies implemented during that first 6 months. Again, I think because a lot of the regs are still being finalized, there still will be a little bit of judgment and discretion as long as you're trying to do it the right way.
Okay,
so
that's interesting.
Here are the kinds of, and here are the kinds of things that we're seeing companies implement in order to verify that the person is the right person. First of all, at least verifying that if it was a request that's being taken by email, or if your communication is via email, that the requester has access to that primary email address. being able to verify that they had access to any other email addresses they're using in the request and or mobile devices, so that you don't have one person essentially making a request for another without, being the true owner of that email address. E-signed affidavits are another set of, things we're seeing customers of ours actually implement, and that's one of the things we stand up. ID verification, selfie checks, including with different levels where you match a photo against an ID, and then some kind of questions to the individual where you're asking either challenge questions or knowledge-based questions to try and make sure that you're, working with the right person. As all of us know, there is no magic bullet that gets you absolutely secure, but by implementing some combination of these choices, you can do a lot to make sure that you have at least done as much as you can to verify that you're working with the right person on a subject rights request. And we're seeing companies implement, both on our platform and through other internal tools, different versions of these as part of a subject rights or an access request.
Well, I was just going to mention that, Justin. As you mentioned earlier, it's important to scale the authentication request with the sensitivity of the information, because there's a balance to be made here between accurately verifying that it is a legitimate request with creating customer friction, right? So you don't want to create huge roadblocks for the request for very simple information. At the same time, you don't want to make it super easy for people to get at health information, for instance, or particularly sensitive information, right?
You're right, and that's what we're seeing. You don't, as a general matter, you want to make sure that if you were ever asked that it's reasonable, the amount of verification and authentication, and you're not making people overdo it. But, these days, a lot of the tracked and observed data is actually quite sensitive, so I think there are very good reasons to be able to implement these different solutions depending on what kind of data. And that brings me to the last request, this last item, which is the tracking, the audit logs, the data, the reporting is really important. I mean, you can see even in the implementing regulations, you're going to have to start pushing out and publishing. You may have to, some of the statistics on number of requests and fulfillment. And doing that manually can be really challenging. So think about systems that can allow you to track and report on that so that you're not having to sit in front of a calculator at the end of the day to do it. And Dave, what that brings me to is really, there are compliance and documentation things that you're going to want to do, like the reporting side and making sure that you can have good demonstrable evidence that you're meeting some of the schedules under CCPA. But because of the focus in CCPA on individual rights and access and opt-out, this has become a very significant data management challenge for almost every company we're dealing with, because you're dealing with the movement of data and how you use data after there's an opt-out request. So in addition to buying your marketing team a coffee or a lunch, the best implementations we're seeing are where there's a close conversation going on between the privacy teams and the IT teams. And that brings us to the main subject that we were going to cover here, which is a lot of the challenge that our community and the privacy world are dealing with is another set of something that can be a bit overwhelming, right? So under GDPR, when we were implementing for companies 2 to 3 years ago, you ended up with companies and privacy professionals that essentially were told, go find everything. Go find all of the personal information. Go find all of the systems. And, a lot of our community, you had to find it with small budgets. A lot of the information was stuck in the minds of people all around your organization, or it's stuck in the technical stack. Because if you have to create a whole series of assessments or privacy impact assessments, there's a bit of a requirement that you go boil the ocean. And it was a lot of work for people to even get to version 1.0, where you could create that set of initial privacy impact assessments. you're going to have to do a lot of that over some period of time. But because CCPA is so focused on subject rights, and because it's focused on being able to enable your consumers to access that data and get it back, CCPA itself in some ways ends up driving a prioritization in a much more natural way around how you stand up your CCPA compliance program. Because what you should do, and what many of our companies are doing, is when you start to go through and you set up the portals to take the requests and you set up the infrastructure to be able to authenticate and verify, the next thing you're going to do is set up those checklists or workflows where you say, if somebody makes a request to us, what systems am I going to collect from? And that critical question, which ones are our priority questions, ends up helping you prioritize which systems you're going to want to look at first. So we see almost every customer start with going to those critical application data stores. So if you sell an application or a web app or have a place where that data is stored, that's one place you're going to want to look at first. You almost always want to go to look at your CRM, like a Salesforce, as a place where you're going to want to collect information. If you have a marketing platform like a Marketo or an Eloqua or an Adobe, that's almost certainly a place where you're going to have customer data that you're going to need to collect. And after that, an analytics platform is probably the next place you'll go where you may have consumer data. I know it goes without saying, it doesn't mean you ignore all of your other systems. It doesn't mean you're not going to get to all of the other operational systems or HR systems. But you have to prioritize in some way. And this element of CCPA allows you to avoid that boil the ocean approach in the first version and have you go step by step through these critical data stores and prioritize your work in the first instance. And so that is something that you can use for your advantage to drive that first version of CCPA compliance without having to boil the ocean, as they say.
Hey, Justin, let me jump in quickly here and say that speaking of boiling the ocean and not doing more work and unnecessary work and trying to be efficient and leverage previous work, a lot of folks on the call accomplished a pretty big lift with their teams in getting ready for GDPR compliance. Would you care to comment a little bit on how much some of that work might carry over in terms of CCPA compliance, that they could leverage that previous work to help with some of the CCPA compliance? Any thoughts there?
Yeah, no, a GDPR program materially helps on the CCPA side. It should lay that foundation where you've done an initial or perhaps much deeper assessment of your major systems. Most everybody who's done a deep GDPR program has a lot of working documentation and information so that when you're going through this review of, hey, where are the critical applications and platforms like CRMs or marketing platforms, you should have a lot of that in your GDPR privacy impact assessments. You'll also hopefully, remember, when you go to a Salesforce or a Marketo or an Eloqua, you're then going to have to actually look in the system to collect the personal information for somebody. If you've done that GDPR work and you've created a privacy impact assessment, you almost certainly have some initial roadmap of what data elements you might need to collect from those systems. Or if you're preparing that category level of information that you need to share with your consumers under CCPA, that those PIAs and those DPIAs have a lot of the base information that you need for that. So I think all of those can serve as critical baselines for prioritizing your work.
Justin, as a quick follow-up to that, are any of the GDPR reporting requirements, would they port over to CCPA reporting requirements too, or are you looking at a new lift there?
New is probably an overstatement. They don't overlap exactly. The CCPA has certain reports and requirements, especially around individual rights fulfillment, that are just a little bit different than what GDPR's focus was. And so I don't think if you just did GDPR, you should assume you'll be, automatically in place with what you need to do under CCPA.
Good to know.
Of course, in the middle of all of this, then you get the draft regulations. And with everybody we're working with and with I think a lot of the community, this has just been a tough circumstance. I don't think it's something we can't tackle, but trying to implement and set up your program in the face of a regulation that was proposed and released, just weeks ahead of when it went into effect has definitely put a lot of pressure on a lot of the community. And the major things I'd highlight here are they're still draft regulations. We've just finished, the process where the Attorney General's office is getting comments. They don't get finalized until, the next couple of months, probably 3 or 4 months into when the law went into effect. And so trying to force compliance with every bit of a draft regulation is not what we're suggesting for companies. What we do suggest is that you look at it as a rough roadmap of where this is likely to go in the next 3 to 4 months. And of course, those draft regulations have a couple of significant things that you ought to look at. The ones that really caught my eye are the provisions around the sale of data can be really worth your attention. For example, if you are reselling data as defined under that law, and again, that's often broader than just technical sale of data, you have to either have very clear evidence that the data that you collected from the consumer, that at the time the consumer knew that the data would be resold, or you have to have some way that you go back to those consumers and let them know that you're going to be selling the data. That even if I cover that at the highest level, Dave, that can be a very tough requirement for certain companies. So you're going to want to look at those draft regulatory provisions. Because if you bought a lot of data and you end up reselling it, you can imagine the challenge on trying to get reauthorized to do that.
Absolutely.
There's some good guidance in the regulations around verification and authentication, and they're worth focus. It covers pretty much exactly what I talked about, but you're going to want to have some escalating levels, I suspect, that are available to you, especially as a technical matter around ID verification and selfie checks and others if you have certain kinds of data. And you're also going to want to look at the upfront notice requirements in those regulations if there's any chance you're selling data as provided in the Act. And I'm going to end up talking about this a few times, but sale of data in the CCPA and certainly in the regulations is broader, sometimes much broader than an actual physical sale or even sometimes a sharing of the data. So just look at those provisions and understand that there may be a lot of benefits to you to being able to set up some infrastructure to take a do not sell request just so you have a record of them. And that you're prepared depending on where the regs end up on what a, quote, sale of data is.
And Justin, if I might just jump in there quickly to add that, isn't it also pretty important along those lines to review the contracts you have with your processors, to use the GDPR language, or your outsourced vendors that handle data for you?
No, that's absolutely critical, because there are not only obligations around what you can do with it when it's a, quote, sale of data, but you have to be able to have contractual protections when you're sharing the data with even vendors. And, if you're doing certain advertising or marketing, as I said, the infrastructure behind that, so that when you share the data with a platform to be able to surface an ad, you're going to need some way that that platform or ad surfacing partner knows whether the information is subject to a do not sell request. So for a lot of different reasons, although it might be a bit of a pain at the beginning, we do recommend that you at least try to capture a do not sell request, just so among other things you can show that you can take it if you need to at that moment. And then of course, Dave, as we get down to these last few minutes before I think we turn over to questions, we have a whole CCPA version 2.0 coming in very likely, in my view, next year. So I know we say this slide is actually focused on what's coming, next year in version 2.0. And in CCPA version 2.0, and I've seen polls that have this polling above 80, 85%. The provisions are focused around things like a data protection agency that's independent, that will be enforcing, the CCPA. There'll be certain use restrictions, especially around sensitive data, that track much more closely to what we've seen in GDPR, and especially something much more like an opt-in version of it as opposed to opt-out for sensitive data. I see a lot of those provisions in the proposed version 2.0 as tracking very closely, Dave, to what was in GDPR, but was not in the first version of CCPA. The benefit, of course, for companies is if then you've done the GDPR work, it'll make it just synced between CCPA and GDPR. My sense is that it gives us a good chance of having a lot more interoperability between some of the California law language and GDPR, but it's going to be a big additional step for a lot of companies, assuming that passes next fall.
Right.
So I know this might be a good point for us to pause for a minute, but what I thought we'd go through here is, on our side, we have the CCPA, what comes next, and obviously these are going to be made available. This will allow the folks to think about taking a prioritized approach around CCPA compliance, where you look at those critical data stores that are really most important for an access request, a deletion request, setting up that infrastructure both in the browser and then all the way through a suppression list for an opt-out of the sale of data. And instead of focusing on creating your assessments right now, focus on being able to tell your story publicly to your customers and consumers around the categories of data, the categories of third party, the categories of sources, and being able to tell a story that you really tackled around CCPA. Of course, on the platform, as we talked about, we have that infrastructure to help with everything from the inventory, the assessments, the vendor management, and subject rights requests as we go. And happy to talk about any specific questions, Dave.
Terrific. That was fantastic, Justin. Great overview. Obviously, a lot of detail underneath all this, but that's some great guidance for those of you out there in the audience that are, I'm sure at this point, probably working on hopefully tweaking or implementing your compliance program, and I know some folks are still getting started, so some helpful information there. I want to make mention of the fact that there is a demo of the WireWheel platform, and there's a live link that you can click just to the right of our pictures there. That will take you directly to a browser tab where you can get a chance to see how the WireWheel tool works, take part in that demo. So that's there for you to enjoy. We've got some great questions that have come in, Justin, so let me dive right in the remaining time that we have and get to some of these. And the first one is one that I've heard before, and I know a lot of people are wondering about, and that is, what if we do not sell or share any PI of our customers? Do we still need to implement the opt-out and other implementations? Good question. What's your response there?
Yeah, no, if you've made a clear determination that you don't sell the data, then you might just say that on your website, we never sell the data. The reason there's a bit of risk around that is because the language of the statute is pretty broad on what constitutes a sale, and it's not very prescriptive. And then the implementing regulations are also a bit vague. So the challenge we've really seen is on getting real assurance within a company that nowhere in your company are you selling data, quote, in quotes, as they put it in the CCPA. It's just hard to get that level of assurance. So, what you could do is, and we've seen language like this, is have a do not sell. The options are you say, well, we don't sell the data at all. That's one option. You could also have a do not sell button that says, we don't sell data as is traditionally defined. There are uses of the data that's, sometimes could be considered a sale, and so we record your do not sell request either way. There are benefits to making sure you have a do not sell request, because you can then go backwards and make sure that you're able to use that if you determine later that you're selling the data as it's defined under the Act. And so this is one of those areas, because the law is being developed, the regs are being developed, and because the language around sale itself is vague, you don't have to do it if you're quite confident, but a lot of companies we're working with do.
Well, and you mentioned earlier, Justin, it was interesting for me to hear that if you want to be on the conservative side, capturing the do not sell request and having a list there could aid you down the road should activities change, data collection and processing shifts a little bit. And again, you want to be on the conservative side. Maybe you capture that signal and have that list in case you need it somewhere down the road.
Yep, exactly. Yep,
okay.
That's exactly right.
And here's another good question following up to some comments you made in that last answer. And I'm going to guess, Justin, that you can't answer this specific situation, but I think it's to generalize or broaden it out. It has to do with what you need to give consumers should they request access to what you have on information that you're holding for them. And so here's the question. Do you have to just tell the consumer what you have, or do you have to tell them everywhere you have it? For example, if their IP address is in 4 databases, do you have to tell them you have it in 4 places, or just say, we have your IP address? So to generalize, and I know there's not a specific question to all this, but just what about a strategy with how much to disclose and what's required by the law? And along the lines, if I could just tack onto this, I know a lot of people are talking about there's the information you hold on folks within databases, and then there's this information that's, for those familiar with the term, unstructured data. So do you have information that's floating around in other places that may not be as easy to get at? And I wonder if you might care to comment on that as an addendum to the question.
Sure, and that's a terrific question. So here's my best cut at it. First, when you're saying where you store the data, there is a requirement in CCPA that you should be able to disclose the categories of sources from where the data was collected, the categories of data you collected, and the categories of third parties with whom it's shared. And so if when you collected, say, a piece of information on somebody, if you're storing it in your own systems and you're storing it then in certain third-party systems, or you've shared it downstream with third parties, then you would need to be able to disclose, at least by category, that you've done that. So if I'm storing an IP address, I've stored it, you can say I've stored that and processed it in my own data stores. I've stored it and processed it in certain third-party data stores, like in the following categories. That is one of the things you'll need to do. Saying that you've stored it in 5 different places inside my own infrastructure, I've not seen any kind of requirement that gets to that level. And then, so to the specific question you asked, Dave, I think telling the consumer by category what you're collecting is something everybody agrees you have to do. There are going to be a lot of circumstances where you're going to need to share back with the consumer the actual data elements, except for certain data elements if the regs are finalized, like social security number or bank ID, that the regs kind of exclude from having to be produced back to the consumer. But sharing exactly what location all of that data stored within your own infrastructure and not by category is not something I've seen.
Probably not necessary. Yeah. Okay. Great. Moving on here, because I'm conscious of the time, and we've got some more great questions. Going back to the comparison of your compliance requirements with the GDPR and how they might map over or not map over to the CCPA requirements, here's a question from the audience. Is data protection impact assessment the same as a privacy impact assessment? What's your comment there?
So they're, under GDPR, they're not the same thing. A privacy impact assessment is actually not required under GDPR. A data protection assessment is a more structured kind of document. There's no fixed one way to do it, but that data protection impact assessment is a required document under GDPR if certain qualifications are required. So a PIA, as it's called, privacy impact assessment, is one thing. A data protection impact assessment is a technical requirement and a document that's required by GDPR, and they're not quite the same thing. And then, of course, the next natural question is, well, how are they different? And this is what the critical thing is. On PIAs and DPIAs, there's no magical template. You will see folks saying, okay, this is the magical PIA template. This is the magical DPIA template. The European Commission has released some guidance about the critical things you should include in a DPIA template. We, of course, WireWheel has one of those. There's also simple, categories or kinds of questions that you should have in a PIA template. But fundamentally, in both of those kinds of templates, you're trying to look at, for any system, what are the kinds of data you're collecting and storing, where are they stored and processed, and who are you sharing it with? Are you doing, are you using the data consistent with the reason for collection, or what are the other legitimate interest uses? It's all around at the highest level. Are you treating the data in a nice, reasonable way, in a way that the consumer would have expected it? So that's the way I would answer that question.
Well, let's not forget that the original intention of a privacy impact assessment is for you to, and your privacy team, to kind of build up the cultural expectations within the company that you're handling sensitive data well, and that you have systems in place for that, and that you're getting at some of the privacy by design principles, and rather than dealing with this as an emergency when new products and services roll out, instead being proactive and using those tools to kind of build up your privacy programs and procedures within your organization, right? So.
Yeah, no, that's exactly right. And of course, like some of the regulators have published different versions of templates, right? The problem is, in Europe, they're all independent regulators, so you have some guidance from some. They have some that have issued templates. It's a little bit of a hard thing, but you can definitely get guidance from some of the European data protection authorities on here's a specific way to think about it if you have operations in those areas, and then of course there are available PIA templates that cover those critical requirements, Dave.
Terrific. Moving on here, this is an interesting question. Getting around to enforcement. Been a lot of talk about this. And the question is, are the AGs by state responsible for CCPA enforcement, or will it be at the federal level? So do you want to talk about what's decided, and still a lot of what's in play here?
Yep, great question. So CCPA is purely a state law, which means that for now it's enforced in two ways. One, the AG has certain authority to enforce for certain privacy type of violations. So you can file a complaint, for example, saying I didn't get all of the data that I was entitled to, and you can file that kind of a request with the AG. There's also the ability to directly enforce the CCPA, either directly or via class action for certain what's called breach liability. So if, for example, one person's data was produced to the wrong person, or you have systems that are not encrypted at rest and in transit, and then it's breached, including the system that is handling subject rights. Those are things that can be enforced directly by a consumer via a direct lawsuit or via class action. CCPA is not a federal statute, so it won't be enforced directly at the federal level. But remember that in the privacy world, the FTC holds ultimate ability in many instances to enforce under what's called their fairness authority. So if you put something up on your website and you say, I'm completely CCPA compliant, and you make public representations about what you're doing with data and you don't do it, you could expose yourself, of course, to normal federal enforcement under the FTC's authority just for making public statements that are untrue. So I don't know that the FTC is going to spend a lot of time on this issue, specifically focused on CCPA, but the FTC does spend a lot of time in privacy making sure that public statements about the use of data are in fact accurate. And so that is a way you could trip into a federal issue.
Yeah, so to your point, be careful about the statements that you make publicly, and know that there is the potential for some FTC attention as well there. And it'll be interesting to see with regard to the California AG's office if 2.0 does go through and that standing up of a separate agency becomes part of those regs, what that would mean and what scale that would look like. So that's a TBD and something to keep an eye on for sure. Now, here's another question that I think all of us have heard a lot regarding the CCPA and scope, who falls under it. And the question is this: is there any impact of CCPA on employee PII data, or is it mostly dealing with consumer data? Something I think a lot of folks are wondering about, and something that's also been a little bit under question, I think, both now and perhaps in the future. Would you care to comment on that?
Yeah, I mean, the initial versions of the law have an exclusion for generally for employee data, and in the version of the it has a time expiration date in the current version of the law, and then in the amendment for CCPA 2.0, the proposed language currently, if it passes, would extend that exclusion for certain employee data for another 2 years. So I wouldn't say you don't need to think about employee data. There's certain circumstances where that can still be covered. They're pretty narrow. But as a general matter, CCPA, as it's going into effect, is really focused on consumer data, not employee data, at least for the next bit.
Yeah, terrific. Well, I'm looking at the clock here, and that's just about all the time we have. So, Justin, want to thank you for sharing your expertise on the program with us here, and thank you to all of you in the audience for being such a great audience and delivering such great questions, and for your attention today. I want to make mention of the fact that, one more time, that there is a live link in front of you on this slide to the right of Justin's picture where you can click, head over there, open up a browser tab, and take the wire wheel demo for a spin, obviously with contact information there, and see how that might help stand up and support your part of your compliance program for the CCPA law. So with that, and before we go, I wanted to ask you all to take just a couple of minutes before you drop off the program and click over there. There's another live link we've got here that lets us know how we're doing on these IAPP web conferences. So if you can click on that link and let us know if this program met your expectations, we certainly hope it did. And also, we've got a field in there that allows us to hear from you about topics that you'd like to hear about on future IAPP web conferences. So please, once again, click on that link, head on over there, give us your feedback, and help us continue to improve these programs. So a huge thank you to Wirewheel for making this program available to all of you free of charge today. I hope you got some valuable information that you can take back and put to good use in your organizations and on your teams. So thank you, Wirewheel, and big thank you to all of you one more time for joining us. And Justin, thanks. It's been a terrific conversation today. Really nice to be able to chat with you again.
Yeah, same here, Dave. Really enjoyed it and hope it was helpful.
Wonderful. And as I mentioned at the beginning of the program, if you're an IAPP certified privacy professional and you have your certification with us, by just registering for this program, you've automatically got 1 CPE credit toward the upkeep of your certification. You don't need to do anything. It's going to be automatically granted for you. And if for some reason you're listening to this as a recording and you have one of the CIPP certifications, you can still get that credit. You can go to the IEPP website. There's a certification area, and there's a very simple to fill out form. It just takes less than a minute, and you can apply for that CPE toward the upkeep of your certification, and we hope you'll do that. And if you're an attorney and you're wondering about continuing legal education or CLE credits, we don't pre-certify these programs, but they are often eligible for CLEs. So what you'll need to do in that situation is apply to your particular bar and find out what the requirements are, get your application going, and you can feel free to reach out to me directly if you need supporting materials. As I mentioned earlier, a recording of this program is going to be made available both on the IEPP and WireWheel websites, and on the IEPP site, underneath the video viewing window, there's a live link there that you can click on and download a PDF of these slides. So all the slide materials will be made available to you. That's going to be posted by the end of the day today. In the airing of this program. You can download that. And if you need other supporting materials, please feel free to give a call or email me. My contact information is on the slide there in front of you. So with that, one last time, thanks everybody for participating today. Hope to see you on another program in the near future. And with that, I'll bring us to a